Welcome to episode 4. If you're new to our channel, check out our first 3 episodes already released. For those returning viewers, thanks for the support. If you haven't already subscribed, please do so. This week, we are moving away from the formalities of articles and will instead be discussing the role candidates will play in their respective law firms, as well as the salary that they can expect to receive. Just a reminder to please take note of our disclaimer. What will my job as a candidate legal practitioner likely entail? Your job may differ depending on the type and size of the firm. For example, the bigger firms are more structured, so candidates are often rotated from departments to experience different fields of law. Generally, however, most candidates can expect to do the following, amongst a wide variety of other things. Take note that if you are doing your articles in a firm that specializes in a certain field, this may not apply to you as much. For example, if you're dealing with mergers and acquisitions, or strictly employment law, or strictly contract drafting, you will probably find that driving, etc., will not apply to you to such an extent. However, to most candidates, the following will be part of your day-to-day tasks. Driving. You'll be driving to court. You'll be driving to court for purposes of issuing processes, filing notices and pleadings, and appearing in front of magistrates. You will likely also accompany counsel and other attorneys in your firm when they appear before a presiding officer. You may also be required to deliver documents to the master's office and the deeds office and any surrounding offices in the area. Candidates in the bigger firms will unlikely have to drive for purposes of issuing, serving, and delivering, as their court messengers normally attend to this. Small firms also tend to employ messengers, but not as many as the bigger firms, so candidates will very likely be required to drive. To sheriffs. You'll be delivering pleadings and notices to sheriff's officers for purposes of having the sheriff serve same on the opposition. You'll also be collecting returns of services and the original pleadings and notices from the officers subsequent to service taking place. You could also potentially attend a sale and execution at the sheriff's offices to protect your client's interests. Each sheriff's office covers a particular jurisdiction, so there are many sheriffs in many different areas. To other attorneys' offices, you'll be attending many attorneys' offices for purposes of serving notices and pleadings. When attorneys come on record for a party, you no longer instruct the sheriff to serve pleadings and notices on the opposition, as you could simply serve directly on the attorney instead. These days, most attorneys consent to service via email, so hopefully you'll not need to drive too much in this regard. To counsel. Advocates are commonly referred to as counsel. You'll be required to deliver briefs, which are instructions, to your counsel's chambers, which are their offices. You'll also conduct meetings and consults at counsel's chambers. Due to COVID, counsels often brief via email, and meetings and consults often take place virtually, so your driving in this regard will be substantially less than usual. For those in criminal law, you will find yourself driving to courts, to police stations, and so on, perhaps to the accused's place of residence and all of that. It must be noted, however, that law firms may no longer require, as a prerequisite, when advertising job posts for candidates, that the candidate have a driver's license or their own vehicle. If you do not have a driver's license, you will obviously not have to drive. Whether a firm will actually employ a candidate without a driver's license is uncertain. Most firms have their own company vehicles, but in the event that they do not, the candidate should be able to claim back petrol and other expenses from the firm. Court attendances, admin. Issuing court processes. All new summonses and applications must be issued. Issuing entails the allocation of a case number and the opening of a file. This is done by the registrar in the High Court and the Regional Court, or the clerk of the court, which is done in the Magistrates' Court. Filing. Whenever a pleading or notice is served, it needs to be filed as soon as possible thereafter. Filing entails going to court with said pleading or notice, together with proof of service thereof, and having it stamped by the registrar or the clerk, depending on which court you are in. You can physically file the notice or pleading by leaving the original in the court file after having same stamped, or you can have it stamped and returned to the office with it. Before a matter is heard, you'll be required to compile an indexed and paginated bundle, which will contain all the relevant served and filed pleadings. In the Johannesburg and Pretoria High Courts, you will file notices and pleadings by uploading them to case lines. These courts are mostly online now. Information on the case line system will have to be an entire episode on its own because it's extremely complicated, but it's been such a blessing. Magistrates' courts are so disorganized that we doubt they will ever be online. Accompanying counsel or senior attorneys to court for matters. Counsel and senior attorneys may require your assistance in court when they are arguing matters. You'll not be expected to do much, but it's very beneficial to watch and understand how court appearances take place. You should take notes of anything important said by the magistrate or judge, as well as either party's representative. Again, in Joburg and Pretoria High Court, arguments is mostly done via MS Teams, which you can just log onto after receiving the hearing link. Some judges do, however, direct that matters be heard in open court, in which event you'll need to physically attend court.
Yes!
Court appearances. Section 65 Financial Inquiries. Every candidate will get to experience the joys of a Section 65 financial inquiry. These inquiries take place in the magistrate's court after judgment has been granted against the defendants. Take note that there's no Section 65s in the High Court. Section 65 hearings are in essence an inquiry into the financial position of the judgment debtor. In the hearing, the judgment debtor, under oath, presents oral evidence as to their financial position. The court will then make an order with regards to the repayment of the judgment debt and associated costs. You will also be doing Section 65J hearings, which are emolument attachment orders, but we'll be discussing Section 65 inquiries and all of that in much greater detail in an episode still to be released. Default judgments. In certain magistrates' courts, default judgments are lodged with the clerk of the court, and as a result, no argument is required. The magistrate will consider the default judgment request on the papers. In other magistrates' courts, the default judgment application will be heard in open court, where you will be required to appear. Also, if you have your right of appearance in the regional court, you may be required to move a default judgment application in said court. Remember, right of appearance in the regional court you will get after 1 year of doing your articles. These applications are generally very straightforward, but we'll also discuss same in much more depth in a later episode. Unopposed motions. Moving an unopposed motion is relatively simple. As no opposing papers would have been received, the candidate will simply need to understand the matter and the law behind it in case the magistrate asks questions. Of course, some unopposed motions can be reasonably tricky, but we are speaking generally here. In certain unopposed motions, but like I said, we'll touch on in a later episode, you can receive opposing papers and still proceed on an unopposed basis, but we'll discuss it at a later time. Regarding criminal law, we don't personally do much of that. However, you will very likely be attending to bail hearings and similar applications. Drafting. You'll be expected to draft simple pleadings and notices, and as you progress, more complicated pleadings and notices. You'll also be drafting letters, sheriff instructions, and emails. Use past examples of the relevant notice or pleading as a template to start. So if someone in your firm has already drafted a notice of bar, for example, use that notice of bar and just change the details on it so you can learn how to start doing it yourself. More complicated notices and pleadings, you will obviously not be able to simply just change the party's details. You will need to do your own work as well. Mundane tasks.
No!
You can expect to do plenty of printing, filing, copying and pagination, opening and maintenance of files, closing of files, and sending of invoices. You'll also be diarizing files. This is a necessary but probably the least enjoyable aspect of articles. It really is time consuming and boring, but it's what you got to go through. Meetings. You will accompany your principal and other attorneys to meetings with counsel, clients, and opposition. As you progress, you will start attending meetings without your principal. When you accompany counsel and senior attorneys to meetings, take notes of the discussion. Research. Research is always required, so you'll regularly be researching legislation, case law, common law, and so on. You may also be required to draft opinions based on the research you have conducted. Whilst being a candidate, the opinions will mostly be for your principal as opposed to clients, because you are still learning. Take note that research doesn't stop once you become admitted. We are constantly researching as attorneys. Taking and making telephone calls. You'll have regular telephonic conversations with clients, debtors, sheriffs, attorneys, and so on. Writing fees. You may be required to record fees for your principal.
Yes!
Take note that what has been mentioned herein about court appearances, etc. is only a brief outline. We will be releasing further episodes later on down the line where we will address in depth, for example, Section 65s and default judgments. If we did that all in this video, it would be a 4-hour video. What advice would you give me as a candidate legal practitioner? If we had to give candidates advice based on personal experience, it would be the following. Carry a pen and notepad at all times. You'll be learning new things so frequently that you'll need to write it all down. Whether it's the procedure to issue a summons at court or how to draft a pleading, take notes. You'll be grateful that you did. Have a proper diary. Make sure to diarize all your tasks and deadlines, as you'll not be able to remember them off the top of your head. Don't be scared to ask questions. Your principal was once a candidate legal practitioner too. We know that you're still learning and asking questions is encouraged. We would much rather you ask questions than sitting doing nothing because you don't know what to do. Before asking questions, try to figure out how to do the task. Your principal will appreciate seeing evidence that you first attempted the task before coming with questions. If the answer to your question could potentially be found in legislation, rules, or case law, make sure to consult those sources first. Let's take prescription for example. Your principal instructs you to determine whether a claim is prescribed. Your first source would be the Prescription Act, and after perusing same, you'll be able to establish the prescription period. You could then have to determine whether prescription was interrupted for any reason. Should you struggle to grasp the concept of interruption, show your principal that you have ascertained the prescription period as well as the scenarios which would interrupt prescription. Your principal would then explain, based on your research, whether prescription was interrupted and why. Attend to instructions as soon as possible. When your principal asks you to do something, if possible, drop what you're doing and attend to the task. If you can't attend to the task immediately, communicate this with your principal. If the task is taking you longer than expected, inform your principal. Communication is key.
Yes! Yes!
Move promptly when your principal calls you into the office. Essentially, do what your principal says within reason, as you want to give off a good impression. Work as many hours as may be necessary. Strictly speaking, office hours are usually from around 8 a.m. to 5 p.m. However, this does not apply to candidates, and in fact, the legal profession as a whole. Candidates are expected to work as many hours as it takes to meet deadlines. you'll very likely find yourself working on evenings and weekends. The extra effort you put in will certainly be noticed. Think of articles like boot camp in the army. You go through hell to be adequately prepared for the real deal. At the end of the day, you're aiming to have your firm retain you as an attorney upon completion of articles. So make sure you give them a reason to do so. Read law books in your spare time. We would highly recommend the following books: Amler's Precedents of Pleadings, the latest edition, Eckhart's Principles of Civil Procedure in the Magistrates Court, and The Survivor's Guide for Candidate Attorneys. Should your firm specialize in a particular field, constantly read up on that field. Read books, read articles, respect deadlines. If your principal gives you a deadline, meet it. If you have to work into the evening and on your weekends, do it. We've already mentioned this. Be prepared. Whatever you may be doing, whether it be a court appearance or a meeting, make sure you are prepared and know what you're talking about. Think about what kind of questions you could be asked so that you already know how to answer them. Solid communication. As has been made evident above, communication is so important. If there is no chance that you can meet any particular deadline, despite working late, communicate this with your principal clearly, instead of simply not meeting the deadline. Remember that you're still learning, so do not make the mistake of not knowing how to communicate effectively. It's really important. Don't panic. If you don't know the answer to something, don't panic and answer with "I don't know." Say, "You need to confirm this," or "I need to obtain instructions from my clients in this regard." Research is imperative. You'll be doing research of some kind almost daily. Figure out what method of research works best for you. Most case law, legislation, and rules can be found online. Even better are law textbooks and commentary, of which your firm should have plenty. It is unfortunately not uncommon to have an awful principal. If this is the case, perhaps try and stick it out. But if the relationship or work environment becomes too toxic, you may want to consider seeding your articles. We will be discussing seeding of articles in a later episode. Your salary as a candidate legal practitioner. From what we have established from chatting to colleagues in the legal profession, your salary as a candidate will likely differ depending on the size and notoriety of the law firm at which you are completing your articles. Candidates at predominantly small firms, I hate to break it to you, but your salary will very likely be dismal. This is not the case at every small firm, but you should expect between 4,000 to 12,000 Rand per month as a starting salary. We have, however, heard horror stories of candidates getting paid as little as 1,500 Rand per month. That kind of salary is beyond exploitation. Candidates must, however, bear in mind that they are essentially interns, and as a result, a low salary should be expected, to an extent, not 1,500 Rand. So we're not necessarily saying it's justified, but it's unfortunately the current consensus among small firms. Should you be employed by a medium to large size firm, you can expect a salary of anywhere between 11,000 to 25,000 Rand. Again, this is not the case with all bigger firms, as there's no set rule as to what candidates should be paid. You could find yourself at a reputable law firm earning less than 10,000 Rand, or more than 25,000 Rand. Upon admission, you should see a reasonable jump in salary. However, being an attorney is not this lavish job that will put you into the top bracket of the richest people in the world, at least not immediately. As a rough estimate, newly admitted attorneys in small firms can expect anywhere between 10,000 Rand to 30,000 Rand as a starting salary. In the bigger firms, you can expect between 20,000 Rand to 45,000 Rand. As usual, there are exceptions to this, but if you are a newly admitted attorney being paid less than 10,000 Rand per month, I would assess my options. Over time, most attorneys should be able to live comfortably with the salary they are paid. But to be really well off, you will need to be in a high position in your firm with a decent amount of experience behind you. It also appears that corporate, where for example you could be a legal advisor and not a practicing attorney, pays a lot more than law firms. Again, this is not always the case. It's situational. You can be at a law firm making a lot more money than a legal advisor at a corporate. Conclusion. We hope this episode gave you guys a bit of a heads up as to what can be expected from you as a candidate legal practitioner, as well as the type of remuneration you can expect. There were a lot of subtopics touched on in this episode, which we intend to go into much greater depth later on in the series. Stay tuned for episode 5, in which we'll be discussing the admission application. If you haven't already, please hit that subscribe button